Okay, welcome everybody. It's good to see everybody here. We have a good crowd tonight. So a couple of words of introduction before I hand the floor to Greg and Mark. This event is called Default, the landmark court battle over Argentina's 100 billion debt restructuring. So we have a very good panel today. Obviously, Greg Makoff was the author of the book that we'll be discussing tonight. Greg is a physicist by training, a banker by profession, and currently a senior fellow at the Masabar Rahmani Center for Business and Government at the Harvard Kennedy School. The book has been out for how long at this point?
A month.
A month, and it's already had pretty good reviews. I know a lot of you have either heard about it or somehow been exposed to it through your work. Axios has called it the rarest of beasts, a book that's both deeply reported and enjoyable to read. And the Wall Street Journal called it a superb account of the saga of the Argentina bond case. So certainly we're in for a good treat. And most of you know the interviewer for tonight, Mark Feldman. Mark is a board member at the Society, and he's a preeminent scholar and teacher of U.S. foreign relations law, transnational litigation, and among other things in his extensive career, he has helped draft the FSIA, so the Foreign Sovereign Immunities Act, and he's spoken about that and other things from his long career in his own book, Footnotes to History, Law and Diplomacy, where he explored his long engagement in U.S. foreign relations. Let me close with a couple words on the host for tonight, which is the Washington Foreign Law Society. Some of you know it, some of you may not, but WFLS, of which I have the honor of being the president, was founded in 1952 to promote knowledge and understanding of international legal matters and comparative and foreign law. So it's a nonprofit. It's member-based, so you can all become members of the society. Please do. WFLS.org is our website. You can take a look at all the interesting events that we have on there, both webinars and in-person events. And let me just plug one interesting event that will be happening very soon, which we're very happy about, which is the return of one of our signature events, the Diplomatic Reception Series, and which is a moment where we typically honor a foreign country, and this year we'll be honoring Ukraine on April 17th at the State Department. So the invite will be out soon, so be sure to keep an eye out for that and come if you'd like. With that being said, Mark and Greg, the floor is yours. Turn your mics on and enjoy the talk.
Thank you very much, Michael. Welcome, everyone. I see a few familiar faces. I think you're all out here, came out to hear Greg tonight. So I'll be very brief. I'm very grateful to Greg for saving a slot for the Washington Foreign Law Society. He began a very busy 2 weeks with the book launch at the Council of Americas in New York, moved on to the Council for Global Development, Treasury Department, IMF, and we're very glad to have him here. Let's get to the subject. Greg, you're going to set the stage. We don't know. Some of these people are experts in sovereign debt. Some are not. So why don't you begin by telling us why you wrote this book?
Okay, well, thank you, Mark, and thank you, Michael, for hosting the event. Sovereign debt is just an unsolved problem. Since something I worked in, and it was a problem in the 80s when the LDC countries defaulted. It was a problem in the 90s with all the Brady programs. It was a problem in 2001 when Argentina defaulted. It was a problem in 2012 when Greece defaulted. And it's still a problem with Zambia 4 years after its default still unresolved. The new scheme to resolve sovereign debt clunking. And so it was a topic I felt strongly about writing about. The Argentine particular case, it was just huge. $100 billion restructuring, the biggest default of its time when it happened. Hundreds of thousands of claimants, 8 different laws, 7 different currencies. And it led to an astounding judicial ruling, which is really at the heart of the book. The judge in New York, Judge Crusade, blocked payments to the 92% of creditors who had accepted voluntarily a restructuring at a deep discount to compel full repayment of the last 8%, mostly hedge funds. Why did he do that? And it also led to a permanent change in bond contracts, the market pretty exhausted with the chaos of these cases. Now, my contribution in this book is focused on the human element, the negotiations, the human failures. It's not a book per se about law and economics. If it's about law, it's about how do the hedge funds use the law as leverage to make money as opposed to a study of the judicial precedents themselves. So that's the background to it.
Well, that's a very good start, but the larger question is why litigation? I mean, there's a long history of sovereign borrowing, sovereign default, stress for the local communities and the international community, but these cases don't always get into court, or do they?
Rarely. The litigation in the 80s and the 90s was at the 0.5% of the claims level. What happened in Argentina blasted away all the precedents. Some people, like Ann Kruger at the IMF, was warning the danger ahead, but people said, oh, no, there's not a problem. But when Argentina defaulted, it became a cause célèbre. But why? And it's a very twisted history. So the first 100 pages is the history, and Argentina wanted a very deep haircut. And Argentina also had a very sore relationship with the IMF. These two things didn't work well together because during the process and the stress over the deep haircut, Argentina broke its relationship with the IMF. So, how do you sell a deal with a haircut? Conventionally, Ecuador, Uruguay, they go and talk to investors in a room like this who aren't very happy about a debt restructuring. But the IMF mission chief stands up and said, we've run our numbers, we think it's necessary, and the prospectus has a letter from the managing director said, please, creditors, take the deal. When Argentina sold its deal, it had broken with the IMF, so there was no air cover, and so they sold their deal on threats. On verbal threats, if you don't come in, you won't get a penny. On contractual threats, some stuff in the bond deal. And then it passed a law called the Lock Law. So its deal was already in the market. It was kind of floundering a bit. They were afraid people wouldn't come in because there's this big battle in Italy with hundreds of thousands of retail investors. And to scare people in it, they passed a law saying, if you don't come in, we will never pay you a penny, we will never reopen the offer, and we will not pay court judgments. And I left out a detail. Argentina was offering 34 cents on the dollar.
That's quite a detail.
So I said deep haircut, really deep. And the creditors in New York and everywhere, the Brady deals were done with a 35% haircut and full payment of past due interest. Argentina was at a third of what they wanted. It was a huge battle. Because of that, Argentina talking tough pretty much worked. 76% of creditors took it, which was much more than anyone expected at that haircut. But they didn't manage the last 24% well. There was no follow-up. They just kind of let it go, and that was $20 billion of defaulted claims wallowing there in default for another 5 years. And they sued and sued and sued. So the first part of the story is how did you end up with these $20 billion of angry plaintiffs? And the rest of the story is how did they sue?
And the first question, when I had the privilege of kibitzing on this book because Greg was interested in understanding how the FSIA contributed to this problem. But my original question to him was why was this in a U.S. court? I mean, from my perspective, with my State Department background and private practice, what seemed really special to me, extraordinary even, is that a U.S. District Court judge, a trial judge, is adjudicating the merits of a dispute on an international scale that affects how many different investors, creditors?
Hundreds of thousands.
And so how do we get jurisdiction? Why were we in U.S. courts, Greg?
The biggest part of the bonds were issued in dollars under New York law, specifying the jurisdiction of the courts in the state of New York. That's how we got there. And if a creditor had other kinds of stuff, they always preferred to litigate in New York anyway because it was a predictable jurisdiction. So it was the biggest volume, but also the magnet for the most litigious investors to put all their energies in New York because it's the jurisdiction they trusted.
So from the perspective of the crow's nest, you have a sovereign state hauled before a U.S. court. Well, the tabloid description that all of you were familiar with this was a drama pitting the vulture funds against a serial defaulter. And who was going to decide this? The imperial power of North America. So let's get to the heart of it. And that is, why did it take so long for Judge Grisey to get this resolved? The whole dispute, as I recall from your book, was 15 years, but we were 10 years in U.S. courts. Is that correct?
Counting can get a little complicated. The default was December 24th, 2001. The first lawsuits were in 2002, and it was settled in 2016. But the litigation got serious after Argentina completed its rough deal in 2005. So there was a little bit of activity from 2002, 3, 4. Then after you have this $20 billion of holdouts, and Argentina said, I'm not going to pay you a penny, the lawsuits skyrocket, and the activity skyrockets. But the activity from 2005 to 10, in 2010 to 16, when the litigation was finally settled under a new government, were very different. And they help explain why the timeline of the litigation was so long. 2005 to 10 was true mass litigation. You had hundreds of cases filed. The Italian cases, there were 3 cases. Underneath them were 200,000 moms and pops. That was stayed technically, and the action was brought in the ICSID. But you had 1,000 plaintiffs who filed 50 suits together with a pair of lawyers. You had a bunch of separate hedge funds not working together. You had a handful of very smart hedge funds working together. You had an occasional bank insurance company, some rich guy with 7 million bonds. So you had hundreds of cases, and you had 8 class action cases. Well, 20 attempted, most of them failed. So you had, and they weren't coordinated. And from 2005 to 10, Judge Grisey, every day, he had another suit and another judgment and another hearing and another attachment effort and another appeals process. And it was completely chaotic. And we don't have a bankruptcy law. There's not a centralized purpose. There's not a stay of litigation. So it's a very medieval process where creditors try to sue and attach. From 2010, Argentina originally got 76% of creditors into its deal. The creditors tried to attach from 2005 to 10, but failed, and then they reopened the offer. Most people leave, and there are only 8% left. There you have the second phase, which are the hardcore holdouts led by Elliott. No more chaos. Elliott says, I'm going to do it. You guys back off. Elliott's lawyers do all the arguing. It becomes an irreconcilable conflict where Argentina is saying, I refuse to pay these holdouts. Maybe I'll give them another offer, but they can't get a penny more than the people who took my offer in 2005 and 10. I couldn't possibly pay them a penny more. That would be unfair. And the holdout said, you signed a contract for 100, you pay 100, plus past due interest. And so they sat there arguing year after year in front of Judge Grisey, neither side moving an inch.
Right.
And that's why it took so long.
Well, of course, those of us who were practicing around the area, I didn't practice in the area. Just to make full disclosure, I was well aware of the economic chaos in Argentina. I was following expropriation issues for a political risk insurer. So this was in line with my practice experience, trying to advise insurance companies on what arguments they could make to resist the notion that what the defaults and takings that were going on in Argentina were not expropriations under international law. And in general, the case became very important for those of us who were interested in litigation against foreign states and agencies under the FSIA. We had a very important Supreme Court decision on the international discovery issues. But the one thing that did not get to the Supreme Court was and this really is, as Greg said earlier, the turning point, the central feature really of this entire story. And I wasn't really familiar with this until I started talking with Greg, was that Judge Grisey decided to break the impasse by issuing an injunction, not against Argentina, but against the American banks who were instructed by Argentina to pay the creditors who had accepted the deal. I mean, that's a shocking thing in terms of the equity of those people and in terms of the international process. And I came to understand from Greg, my question to him is, why did Judge Grisey impose that? And what motivated him to take this extraordinary step?
This is the essence of the book, is why did Judge Grisey do this? And while I was researching the book or even thinking about writing it, I'd go to a conference at the Council of Americas in New York, and maybe it was on Venezuela, but the conversation always touches on Argentina and Judge Grisey. And one of the top lawyers in the room who was on the panel said, "Oh, that was a weird decision." And it's not a weird decision. It's an understandable decision if you go through everything he saw over the years and the arguments made in front of him and the behavior of all the parties. So the book really lays out the case where it's like you're sitting in his chair watching all of it. So you can decide, was it crazy or not? But as far as I'm concerned going through it, there is a logic to it, but he's very frustrated because he lacks the bankruptcy powers, carrots and sticks, to force an end. He can't stop the litigation with a stay, and he doesn't have discharge power. So if 76% settle, or 2/3 like in U.S. bankruptcy, you bind the rest in. You can have 76%, 92%, 99%, but you can't stop the litigation for the rest of it until there is a voluntary settlement. And he gets frustrated with that, but nothing in the book says, "Oh, I'm tired of working on it." He gets morally angry at Argentina on a lot of accounts. They're a bad debtor who keeps doing bad debtor things, and the plaintiffs keep pointing out the bad debtor things. And he keeps, when the injunction, there's an underlying covenant ruling before you get to the injunction, something called a pari passu clause that doesn't particularly matter for the injunction. When they get to that ruling, he says, well, I don't really want to do it, Argentina's side, so can we talk about paying these debts? And Argentina says, oh, maybe we'll get around to it someday. Okay, I'm going to impose this. And that happened again and again. Argentina had no constructive solution, while the plaintiffs had something he could do. And if Argentina had changed its mind, it could have been a different story. So it's really a question of frustration. And this repeated at the Second Circuit, which is more extraordinary. The Second Circuit, after a second hearing, each an hour and a half long, wrote a letter to Argentina a couple days after that hearing and said, you know, Argentina, you're a government. We're about to impose this injunction. Could you live with anything other than this particular formulation, which had, if they paid anything to the 92%, they had to pay every penny owed to the 8% in full, the full claim value, the par, the past due interest, everything, which is kind of extreme. You could force them to pay in blockade, but the amount they paid was the worst possible case. And Argentina wrote them back saying, nope, my way or the highway. And the Second Circuit's second opinion was, you are the uniquely recalcitrant debtor. You have disrespected this court. You have complained about us in the press. I mean, it's the sort of thing the Supreme Court just doesn't want to look at this. It's a New York law contract. It's a debtor who's disrespecting the court. At that point, they don't even get an amicus brief from the United States government, who had been supporting Argentina up to that point. So that's the end of the line. And
let me interrupt you here,
yes,
because
yes.
I think you need a rest, and I think I have to say a word about the FSIA to get the full context. My proposal to Greg was that the title of the book should be Angry Judges. Other people thought that was a little bit too particular, but if you were a litigator, you understand that judges, if you get them angry enough, can do unpredictable things. The FSIA, to put it very briefly, I mean, if there's interest, we can do more in the Q&A, but we're going to have to move on to that soon. But basically, it is very generous in providing jurisdiction in U.S. courts, especially when you have a contract for financial contract, a commercial, non-governmental function as perceived, as legislated by the U.S. Congress, and you have in these contracts, these loan agreements, a waiver of sovereign immunity by the parties. You have parties that consent to the jurisdiction, but there's very little opportunity under the Foreign Sovereign Immunities Act to execute a judgment. And by the time you get to this stage of the litigation, you not only have a serial defaulter, a recalcitrant debtor, you have unsatisfied judgments. So now it's not just a question of equity at large, it is deliberate, willful disrespect for the judgment of the court. And so that's what's driving the judge in this case. But this is just the turning point. There's much more to this drama. And I strongly recommend that if you're at all interested in the strategies of litigation and the management of public policy in U.S. courts, you have to get this book. Greg, let me ask you, how was this resolved? So you have the injunction, which really gets the attention of every bank in the world. That's where did the court take it from there? What was the Argentine reaction?
Well, this situation led from unprecedented situation to unprecedented. So the deal itself, the default was unprecedented. The imposing the injunction was unprecedented. When it came, all the appeals were done, and Argentina didn't get a hearing. The injunction sprung into effect in June 2014. So Argentina had 30 days to settle or go into default or pay. And Argentina finally said, okay, we'll send someone up to New York to negotiate, but nothing converged there. And Argentina, when pushed to paying these hedge funds, who they've been railing about in public as the national enemy for a decade, or going into default, the president and the finance minister decided to go into default. So they went back into default on the 92% just to avoid paying the 8%, to avoid giving in, and they attacked this judge. They don't call it a default, they call it a grifault for Judge Grisey. Personal attacks on the judge, full-page ads in the newspaper. But we forgot a detail. Remember I said they sold it on threats. They passed a law called the Lock Law saying they would never reopen it. They would never pay a penny to holdouts, and they would never pay court judgments. Well, the plaintiff's lawyers put that in the judge's face again and again. They're disrespecting you. They signed bonds with broad waiver of sovereign immunity. They agreed to the jurisdiction of this court, and they passed a law in their Congress saying they will never pay their court judgments. He repeatedly ranted about the law. He said, when he said there was this breach of this pari passu clause, that law by itself breached the clause, but it proved the key to unwinding the mess. Because when Mauricio Macri won the presidency in November 2015, vowing to settle this mess, he sent financial experts, former bankers, up to New York to talk to the special master who'd been assigned to help arbitrate it. He said, we want to solve this. But some of these guys are asking for like 10 times par because of funny derivatives embedded in their bonds. We're not going to pay that. Maybe we'll pay 70% of their claims, but no way we're paying 100. So they wanted to negotiate at the margin, and they cut a few deals. They cut a deal with the remaining Italian retail investors, with a few of the hedge funds, and they went to the court and said, now will you lift that lock law? We're now behaving good. We're being nice people. The court was so exhausted from all this trauma and default. The court never thought Argentina would choose to default, completely shocked by its decision. And Argentina said, we'll lift the lock law too. And that was the thing that always upset the court. So when they said, we'll pay everybody out and we'll lift the lock law, and he says, if you do both of those, I will lift the injunction. And that's what his court order said. And so in the end, they lift the injunction. The hard court, the 65% of the claims were held by 4 big hedge funds. They didn't want to settle, but once he said he'd lift the injunction, they had to settle on the same terms as the others because they had no bargaining power because it's too hard to attach. But later that year, some other hedge fund said, I want an injunction. And the judge says, oh, well, they got rid of that lock law. In Argentina, used to be uniquely recalcitrant, but they've changed their behavior, so no more injunctions from this court. So the court, in the story, does this horrible ruling that is very favorable to unhelpful holdout investors and completely takes it away at the end after Argentina changes its tune. So
one other thing, Greg, that I would like you to share with the group. I was absolutely fascinated when I read the book to understand the role of the court-appointed master. And you've got an expert, as far as I can tell, a fair-minded, hard-working guy. But the thing that really struck me is the leverage he had in mediating this thing, not arbitrating.
yeah.
He's not an arbitrator. He's a master, but he's an intimate friend of the judge. And he's got the leverage of knowing that what he proposes, the judge is very likely going to enact. You want to say anything more about that?
If it's a movie, it's a buddy movie.
All right. Okay, so one last question before we open it up to the floor. So how did the markets react to this? You started by saying the problem here from the heavenly perspective is that there's no international bankruptcy process for sovereign debt. Are we going to get to that, or is there another solution?
No, what I'd say is that there's a big sort of problem created in Washington when some State Department lawyers had the idea of passing this thing called the Foreign Sovereign Immunities Act. In 1976, that created the right to enforce. There had always been the right to sue, but it created this right to enforce in part. And that meant from that day on, any investor could try to hold out of a sovereign debt transaction and sue and sue and sue. Because without a bankruptcy process to force an end and discharge powers, you kind of took this genie out of the bottle.
Well, I would put a little different twist on that. The historical context is that the United States was the first government to legislate to create a statutory basis for judicial determination of questions of immunity. And for the most part, we can, being exposed to reciprocal treatment in foreign courts, we had to stick with things that were being done widely, at least in the Western world or the capitalist economy, international economy. There, at that point in time, no one had allowed enforcement, execution, let me be more precise, execution of judgment under the restrictive theory. So what we did was a bit of a gamble.
Yeah.
And we provided a very narrow right to do that. And we don't have time to go into the details. But so I think what this did was it did not give the lesson that I would take away from one of the lessons from this experience is not that the FSIA provided the leverage for execution, enforcement. Now let's talk about that in those terms, because execution is just one means. Quite the contrary, it generated the frustration with the statute on the part of every plaintiff out there, and in this case, the hedge funds, but that Argentina took it a step too far. And you talk about the litigation tactics in the book, but you've exposed, and I come back to my theme, when you have a judgment and you disrespect the court, then you're exposed, and if somebody here might have read I have not read the Second Circuit decision recently, but as I recall, they basically said, this is a trial court. It's got a very difficult decision, and federal courts have equity powers, and we're not going to interfere with the court's exercise of its equity powers in this circumstance. So, a sovereign that wants to get a judge angry is taking a chance. From my perspective, it was not legally well founded. It was, and from an international perspective, it was outrageous.
But let me explain, because when you go through the attachment parts, so there's lots of failed attachment that leads up, lots of time in court. They try to attach an airplane. They try to attach some bank accounts. They try to attach some central bank reserves. They try to attach a satellite guidance system. They tried discovery on 20 different oil companies. Action after action after action. They're in court, and this Foreign Sovereign Immunities Act, Argentina's lawyers saying, we're immune to everything, look at the text of the law. And the plaintiffs are saying, no, but it says this little thing over here, and we should have the right to execute here because it says that in the law. And it's like they're describing two different laws. In effect, it was really hard to attach, which was the intent as you describe it, but it was ambiguous enough, and there were enough precedents. The litigation churned up a lot of effort, but what happened is The mess of the litigation upset the market, and this blockade on 30 billion of bondholders made them very unhappy. And U.S. Treasury said, you know, guys, why don't we will never get a sovereign bankruptcy law through the United States Congress and the European Congresses and all around the world. Why don't we put quasi-bankruptcy powers in bonds? Put something in bonds where if 75% of the holders agree to a deal, it's binding on all 100%. So it's kind of a coercive mechanism, a kind of cram down against holdouts to put them out of business. And so technically this started in 2003 under Undersecretary Taylor in response to a more complicated international court proposed by the IMF, but it was very weak. And in 2012, after the first Second Circuit ruling in Argentina, U.S. Treasury started up the engine again and said, we need to have this voting scheme where if a country has 50 different bonds, they all vote together in one big vote.
What is the phrase that you're looking for?
Collective action clauses.
So these are commonly in
Since 2014, every single sovereign bond, except one or two at the margin, have these. And as countries have been restructuring again, they're using them. Argentina and Ecuador restructured again in 2020, had these clauses or similar ones. No holdouts, no holdout litigation. The problem is, call it 90% solved.
All right, I think that's as far as we can take it right now. I'm hoping that there are a lot of questions. The floor is open. Who would like to? Yes, please.
So, forgive me, this may be a naive question, but did the Argentinian government have the capacity to pay what the bondholders were requesting? Was Argentina simply stating its case because it could not meet the demands of...
You hear the question?
Will you repeat it for this?
Hey, the question is whether Argentina had lacked the capacity, had or did not have the capacity to pay the bonds. So I'll leave that to you.
Yeah.
That's a moving target, I think. But
Yes, at the beginning, Argentina was in a horrible, awful crisis, like our Great Depression. Judge Grisey, for 5 years, completely protected Argentina. He stayed actions against him. Creditors, at the time they were doing their exchange offer, he browbeat them. He said, sometimes it's better to take something small instead of getting nothing, running around the world trying to attach things. So he was Argentina's best friend. But after starting around 2008, he's getting tired and starts making odder and more negative decisions. So what happened was Argentina started booming. They started booming. They had restructured their debt. Grain prices were good. They're having China 8% growth. And so the plaintiffs bring that into court. And he has a hearing where he's got 50 pages of complicated legal arguments about an attachment, and he's really not interested in it. And he says, I found something interesting in page, at the last page here, it says Argentina's doing well. So why aren't they paying? So when they bring pari passu, and there's only 8% left, Argentina has $50 billion of foreign reserves in its central bank, and the claims they brought that suit on were less than $2 billion. So there was absolute ability to pay at the time he imposed the injunction. At the earlier dates, there was a time at which they transferred from unable to able to pay. But it's a great question. Thank you for asking.
yeah, yes. Next, who else has a question? Please.
Could you talk, or did you talk to the hedge funds about how they were making the calculation of paying this constant stream of legal fees against this probability that they might get something one day? That's, as an economist, I think, people working in finance, the calculation a derivative is usually much more straightforward than all the probabilities that they must have had to weigh to think about what they were paying the law firms on an ongoing basis versus what was coming in the future, potentially, maybe not.
That's another very good question, because you know something about how they make money.
Yeah, you repeat the question for them.
He wants to know, how did the hedge funds, considering the legal bills that they have and the other investment opportunities that they're foregoing, why did they go this route? And I think, as I recall, they made some money on this deal.
Well, it's actually really fascinating because you have hundreds of plaintiffs, and you've got lead plaintiffs who are spending tens of millions of dollars on the best lawyers in the country, former Solicitor General Theodore Olson, who won Bush versus Gore and Citizens United and gay marriage rights. Great lawyer. And then you have others who are free riding. They're like, oh, well, let Elliot do all the work. And I actually, with Professor Wiedemeyer at UNC, we wrote a law review article in UC Davis Law Review last February where we scientifically analyzed all the strategies of all the plaintiffs. Now, they're not going to tell me that stuff, but we pretty much backed it all out because we can figure out how much they spent on legal fees. That's not really in there, but how much they spent lobbying, because they also lobbied Congress. They spent $36 million. So
Why don't you elaborate? I think they'll be interested in that.
The lobbying.
The lobbying point.
Yeah, no, it was they bought their claims very cheap, which you can know from the dates they bought the claims, because every complaint, they have to put what day they bought the bonds. They white out the price, but you know what the price is on a particular day. They bought them very cheap, the lead plaintiffs, because they were disciplined and they knew it would take a long time. And you can figure out, Elliott in particular, in the credit crisis, they bought more bonds at like 15 and 20 cents. And then they bought some securities that paid off 10 times par. So it's very easy to calculate that even if Argentina reopened its deal at 34 cents on the dollar, with their legal expenses, they would break even. And so other people were less efficient than the smartest one in the room. And so there were leaders, there were followers, there were sophisticated, there was unsophisticated, and it's quite a universe of different plaintiffs. And in the middle chapters, I kind of introduce the different groups. There is no the market. There are a bunch of different people making up a market, and even within litigants, very few really know what they're doing.
It's an amazing world, and I can never master it. But you had a question, sir?
Yeah, so maybe this is too in the weeds, so you can answer it as you like. But I mean, one of the things that's interesting that's going on is the compounding of interest. This is 15 years. These are not low treasury rates, these are higher rates. And then you've made reference to the FRANs, or the derivative instrument. So my understanding is that a country could not issue bonds that are senior to other bonds that have been issued and get in the front of the line. But I guess you could issue a bond that, if we default, starts paying 100% interest a year and compound that. Is that, there's, I mean, that's, the contract obviously wasn't anticipated. Was there ever any attempt to kind of relate that to like it being effectively senior, like getting a sort of crowding out all the other bonds? Did anyone ever make that argument? Has that ever been?
Yeah, let me just tell the story of this bond, because it's not evident since people haven't read the book. Is Argentina defaulted on about 82 billion nominal of bonds that were eligible for the deal. They waited so long to do the deal. By the time the deal came, there was 20 billion of past due interest. So it's 100 billion restructuring the principal plus the past due interest. 300 million of the 82 billion were a funky little bond. Those bonds settlement cost them $3 billion-ish. In the final holdout settlement, out of a total of 10. Those 300 cost about 7 times their principal amount.
Why was that?
Well, they were a derivative done by one of those fancy banks up in New York, and usually have a fixed rate bond at Argentina, 10, 11%. And then sometimes, you have a floating rate bond, US LIBOR or Fed funds plus 3% or 4%. But this time it was creative, really value added, saying the spread will be the spread of another Argentine bonds over treasuries in the secondary market. So another Argentine bond traded at 12% in the secondary market, so that year you would set it at 12. But then if the next year things were bad and that other bond traded at 14, this bond would reset at 14. And if you default and that other bond trades at 100%, your bond resets at 100. So this bond reset at 8 and 8 and 8 and 9 and 10 to 30 to 100. And then for some reason they stopped paying the agent that calculated it, and it was stuck at 100 forever. So these plaintiffs had a claim. They got their judgments in 2009 composed of par plus 8 years of interest at 101.5%, plus interest and interest at the New York statutory rate of 9%, which totaled 10 times par. And I believe Elliott bought theirs late, let's say 35 cents on the dollar. And that's one piece of profit, but that was only 300 million bonds that turned into 3 billion of claims. The holdout debt was a total of like 7 billion par amount after the 2010 offer at the end. A lot of the plaintiffs, let me go into the last bit, is there's something funny about US litigation. I don't know how many people in the room would know. When you get a judgment, a final money judgment from a federal court of, let's say, $1 million, it accretes from that date at the 1-year T-bill rate. So if that judgment is paid in a year, you take that $1 million and then you accrete it at the T-bill rate for that year of time. And if, as rates were around 2005, near 1%, once you got your judgment, it doesn't grow very fast from there. A lot of plaintiffs, thinking they would collect soon, in 2005, 6, 7, 8, got their judgments for like 1.5, 1.6 times par, but since they only got paid in 2016, they're only growing at 1% a year. Now, if you're smart, like the few of the smarter hedge funds, they say, well, we don't want to get a judgment. We'll sue to stop the statute of limitations from running out. But before the judgment, you accrue at the New York rate, which is the coupon on the bond and interest on interest at 9%. So those guys, their par claims from 2001 by 2016 grew to 4 times par. And those are bonds some of the hedge funds bought in the credit crisis at 20 cents. So they're going from 20 cents to 4 times par. And so there was a lot of money made from buying cheap, not getting judgments, as well as the derivatives. I explained like a sprinkling of this math in the book. It's not a mathematical book, but if you're mathematical, you'll get it without having to see calculations. But it kind of discloses the secret of what hedge funds really do all day long, which was find the securities and tricks to maximize accrued interest.
Well, I will never understand the math, but you have persuaded me, as to quote someone else, the system is rigged, right? All right. I don't know about elections being rigged, but the economy and the legal system is really in bad shape. Let's have one. Yes, sir.
Were any of the plaintiffs motivated to a significant extent by the precedents that they might get from the Second Circuit?
The questions were, any of the plaintiffs motivated by the precedents?
What they were looking to make law in the Second Circuit, is that your question?
You know, everything people did was kind of justified in their own cases, but where you see that happen is when they intervene in other people's cases. Because Elliott might have one case going here, But then another hedge fund badly argued something. And then they send a brief over saying, well, I want to help the argument a bit here. So there are a couple cases where Elliott intervened or did a brief for other cases because they really cared about the precedent. But I don't judge why people did things. I show what they actually did for you to judge. So the things talked about in that I see in the story are all pretty well justified by themselves. But
Well-
they do care. I'd say the one case that went to the Supreme Court was on discovery, and they never got a lot of discovery. It was the international scope of discovery. I don't think
I think we're getting in the weeds of foreign sovereignty.
Yeah.
We need to bring this to a close. Unless someone has a pressing question, I would like you to conclude by sharing what you have written about the lobbying effort. What were these guys trying to accomplish politically in this situation, and did they succeed, and how did that play out?
One of the facts disclosed during the course of the book and was always there during the course of the story was this lobbying. And there was this group called American Task Force Argentina, which was funded by the hedge fund. And we know who they were because they listed their membership on their own website. And you can go back to the Wayback Machine and recover their old website, and they list who they are. And I've put that in the book, and nobody has complained. It's inaccurate. So what I found later was that they were incorporated in Virginia as a, 501c4 corporation, which means their tax records are available. So before they disappeared, I downloaded all of them and found out that they spent $36 million, a lot of it with DCI Group here in Washington. What I know of their activities is from their own website and from press releases and newspaper articles about what they did. And they were generally talking about corruption in Argentina, Argentina's bad deal, bad trade, and not paying their debts. The formative purpose of the organization was, we are plaintiffs, we're owed $3 billion in judgments, we want to get paid. And after they got paid, they closed down the organization a few weeks later. So it was for the purpose of that, and it was pretty open. But a lot of the focus is my inference, which is in the conclusion, is they really, really didn't want the U.S. to send an amicus brief to the Supreme Court. Is that you can hedge a lot of risks in a litigation process, but the one thing in a sovereign debt case with foreign countries is if the U.S. government is going to say we have a great relationship, or this is really going to hurt the global economy, it's a big public policy issue, that's kind of an unhedgeable risk. My feeling is they understood that from the beginning, because their experts keep harping on the U.S. government interfering. Now, in 2012, the U.S. sent 2 amicus briefs to the Second Circuit. Please do not affirm this ruling. But when Argentina appealed to the Supreme Court, the U.S. did not send one under heavy lobbying. But at that point, Argentina was attacking the court and was having a lot of other bad behavior, and the briefs themselves were really not good. They didn't address this lock law thing I talked about. So,
Well, there were other bilateral
Yeah.
issues with the incumbent administration also.
Yeah.
It's an absolutely fascinating story, and I think we're grateful. I'm grateful to Greg for writing the book and for sharing the experience here tonight. And good luck. I hope it sells well. And I look forward to your next project, which is, I'm sure, going to be in the public interest to try to plug some of these holes in the system.
Well, Mark, let me thank Mark. I reached out about 3 years ago for help with a little backstory. It ended up with, well, can you help with Chapter 5 and Chapter 8 in my conclusion? And he's been a great friend and taught me a lot in this process. So it's an honor to be here with you. And thank you to Michael and the Washington Foreign Law Society.
And my last word is, if you like this program, join the Washington Foreign Law Society. There's a lot more in the future. Thank you very much for coming.